Hey, I'm Alan Childress. I'm the law professor at Tulane who also teaches notary classes on the side and writes notary books. So check out our books at Amazon. Childress Notary 2025 would be good. Well, the forms book is last year, so we'd say 2024 on it, but it's still valid and current if you're interested in a forms book. Just talking in the background because Michelle is helping out some clients at our shop right now. And so I have just a shorter YouTube, probably not short compared to many of the YouTubes on here, but I've learned you got to do more snippets and less half-hour ones. This is mostly for commission notaries because there's some tips on practice that you might not have gotten from the study guide when you were becoming a commission notary that I'd like to share with you. But it's also for people who are studying for the exam in that I'm telling you the exam answer in addition to the real life one. So Michelle and I came up with a list of about 12 things where we think that deviates, like real life is different from the best answer or the model answer, which is not improper. That's true in legal practice as well, that a lot of times what the statute says is the minimum isn't at all what you would do in practice, or the custom is to do it differently and everybody accepts that. And so, you did a lot to pass the exam, and now it's time to learn a few tips that go beyond that. That's what this is. So I got 12 in all, but 6 that I'll do in this YouTube, and maybe a week from now do the other 6. Okay, so number 1 on my list is that the study guide makes a big deal, and the exam makes a big deal of the difference between procuration and mandate, that those two terms are used for subsets or types of power of attorney. In practice, I don't think people worry about that. If you get the label wrong, the court or anybody would consider it valid as a power of attorney. So you can call it like a medical mandate as opposed to a healthcare power of attorney, and that would be fine. Technically, the difference is that the procuration is unilateral, that it's signed by the principal, but there's no agent yet to sign it, even though an agent is appointed or mentioned in the document. They haven't agreed to it yet and signed it. So theoretically, they could sign it 20 years from now. That's fine. But the reason it really doesn't matter is that once they sign it, it's treated as a mandate anyway. So it's a question of when they sign. Do they sign it immediately when it's drafted? Everybody get together. It's often true. Then that's technically a mandate. Is it just kind of left open, not who the agent is, but when they sign? Well, then that's a procuration. But really, it doesn't matter what the label is. Therefore, do what lawyers do, just call it a power of attorney. I recognize that's a common law term, but it is all encompassing. It covers both of them. And so whether you draft it with the agent going ahead and signing it, or the agent signing at a later date and you put the signing part of the agent kind of at the bottom, I accept the appointment of this agency and all its duties and responsibilities, and then have them sign it with a date line that's different and is not part of your notarized, that'd be fine. But again, a lot of people just show up with everybody together, and you can have their signature above the notary part instead, if you wanted to, and have everybody sign at that time, and then it's technically a mandate. So the exam answer is it's important to know the difference between a procuration and a mandate, but in practice, just call it a power of attorney and you're covered. That is especially true with conditional procurations that the study guide calls conditional procurations, and the implication is that you can only do a conditional one in a procuration. That isn't true. You could do a conditional mandate as well. So just a conditional power of attorney. They're explaining it there because a lot of time the conditional ones are not agreed to and assigned by an agent until much later when it's ready to be used, when the condition is met. But they could sign it right at the agree to be the one in that situation in the future, in which case it's a conditional mandate if you think about it. So you could just have it as a conditional power of attorney. By the way, the title, again, you wouldn't say conditional power of attorney, just call it power of attorney, healthcare power of attorney, or separately a general power of attorney, and that would be fine. So those terms are interesting for test purposes, but not really that useful. Number 2 is that the general power of attorney can include a statement that it authorizes medical or healthcare decisions. and often does. It's part of a general power of attorney that also has finances and tax, and you'll control my real estate and you'll help with my bank. It can be in there, and the study guide says that it can be in there. In practice, a client probably needs them to be a separate document. And it's because the general theme of this YouTube is that a power of attorney is only good as the person accepting it is willing for it to be. That is to say, no one's forced to accept your power of attorney unless you take them to court, in which case you don't need a power of attorney, you just take them to court. So if you want the power of attorney to be effective as a notarial document, the key for every tip we have is to do it in such a way that it's more likely to be accepted by a hospital, by a bank, by a real estate situation, or a pharmacy. It's just important to get it accepted. And to that end, hospitals and doctors and others want to see a power of attorney that is focused on medical. So when a client says, I just want one document that takes care of everything, you need to say that could be a problem. A lot of people won't accept it as a medical one, even though it has medical terms in a general one, because they think it's buried in there and not really paid attention to. So my recommendation is to always do it as two separate documents. If they want all of that covered, cover it through two separate documents. Hospitals are just going to have a real problem with just one little line about medical decisions with 2 pages of banking and other decisions in there. Number 3, the book says you may not need 2 witnesses. It may not have to be an authentic act. And for exam purposes, it's really important to figure out that some power of attorneys have to be authentic acts and some don't, so that you can answer the question appropriately. And the reason for that is the rule is, as you know, or the exam answer is, a power of attorney has to be an authentic act if the thing it's authorizing has to be an authentic act. So if the power of attorney is being used for a donation, then the real estate attorney who's using it at the closing will look to see whether the person signing it, one, has the specific authorization of donation. We know that's required. But specifically, since the donation has to be an authentic act with 2 witnesses, then therefore the appointment of them in the power of attorney has to be an authentic act. Whereas something as simple as signing a lease, you authorize somebody to sign a lease for you, which doesn't have to be even notarized, much less an authentic act, need only be in the form that the document authorizing it has to be in the form that it's whatever it's authorizing. That's the exam answer. In real life, it's always better, if possible, to have 2 witnesses. So even for that authorization of a real estate deal that may not require 2 witnesses, authorization of healthcare decisions that may not require 2 witnesses, I would still always draft the power of attorney with 2 witnesses and have 2 witnesses observe it. And once again, the reason is maybe the hospital thinks it needs to have 2 witnesses and will then, in a crucial bad situation, start arguing with you over why didn't you get 2 witnesses with your power of attorney. We won't honor that. And yeah, they could eventually go to their attorneys and get yours approved. Don't put your loved ones in that position. Instead, get it done as an authentic act at the time, and then whatever it authorizes will go through. That covers everything. It doesn't just cover the donation, but it covers that recalcitrant pharmacist that says, well, we only use powers of attorneys that been witnessed, and yours doesn't have that. And you can argue till you're blue in the face that that isn't the exam answer, and that won't help you at all. So the tip number 3 then is you may not need 2 witnesses, but yeah. So the 4th tip goes back to, will it be honored by this person you're presenting it to? Well, a general power of attorney is widely applicable and has lots of provisions in it covering a lot of things. If there's really, though, a question as to whether a particular entity will accept it, it's better to write one that's specific to that entity. Or even better, call Fidelity, call that bank and say, do you have a preferred power of attorney form? And do their own power of attorney the way they want it. So the more general it is, I guess the less likely that ignorant or recalcitrant sources will honor it. They'll think it's too general and it isn't focused on them. And a general works for a lot of situations. I'm not saying that it's not good. I'm just saying there are going to be some entities, especially places that deal with large amounts of money, like an investment account or a retirement account, that will say, why didn't you use our power of attorney? We make it available to the principal when they're alive or when they have capacity. So one thing you probably need to tell your clients, not legal advice, but just practical advice, is that, hey, probably you should call up some of these sources and find out if they have their own specific power of attorney they prefer. And they may honor yours, but why put them in a position where they're having to decide whether your general power of attorney is good enough when they have their own form? And again, maybe make the client do the work for that. You don't have to represent them. You're not an attorney. But yeah, I would definitely consider that. There are other situations where, like Social Security, where a general power of attorney probably doesn't work, but you can do a special form that they have for Social Security. I think now they may even allow it to be done online, even without a notary. So Social Security might be a situation where, again, you would want to authorize that separately. Look into that if that is an issue for a client. Number 5, true copy is mentioned in Chapter 29. It's one of the general miscellaneous acts that the people studying for the exam learn about true copies or certified true copies by a notary. One of its most useful aspects, though, really should be in Chapter 15, or understandably isn't there, but that's where I think you'll wind up using true copies a lot. You won't use them for a will, where there's going to be one original and true copies aren't going to help you at all. But for power of attorney, offering a true copy, maybe charging a little more for it, but still offering it as an option, lets them walk out with more than one original. And the reason that matters is, of course, the hospital and the pharmacist and the bank and the IRS all will want to see an original. And if you have one original that you use for every purpose and make them copy it for their files and take the original back, that's fine. But if you have a few true copies which act as originals, then you've covered that and can leave that with them if they want you to. And number 6, durable. We know the exam answer is that Louisiana power of attorneys are durable by default, meaning that they survive the incapacity of the signer, of the principal. So if the principal is no longer able to make decisions, the power of attorney still works. In other states, and maybe stupidly, it ends on the incapacity of the signer. This isn't about conditional power of attorney. This is about the duration or termination of the original power of attorney. Does it end when the principal loses capacity, or is it durable? It continues past that. It's not going to be durable enough to survive their death. And a lot of clients don't understand that. They think that a power of attorney will be a good way to handle things in their estate, when in fact it can't do that. But it does survive the incapacity, physical or mental incapacity of the principal. That way it's durable. I will say the tip, though, is to, I think this is tip number 6, so I'm going to be done with this, is to still include a phrase in the general power of attorney or the healthcare power of attorney that says that it does not terminate upon the incapacity and should be considered of the principal and should be considered a durable power of attorney or a durable healthcare mandate or something like that. That's, again, just a matter of what if the hospital is looking for the phrase durable and doesn't find it and says, well, we can't use it now. Well, don't put them in that position. Just go ahead and say it. So the default rule, the exam answer, it's already durable. But the advice is either put it in the title or put a paragraph in there or both that simply says that it does not terminate upon the incapacity of the principal and should be considered a durable medical mandate or a durable general power of attorney, whatever the document is. I think that there's no harm in putting the word, if that is in fact the intent of the principal, that they want it to do that, and most of them do. Definitely throw the phrase in. Oh, and another reason for that is not just the hospital might be ignorant, but other states have different rules. California, it's non-durable. They may not know Louisiana's rule, and maybe it will wind up being used in California. So again, a Louisiana power of attorney that will be honored in California most likely may be interpreted wrong in California because you didn't put that phrase in either in the title or in the document itself. So that's tip number 6. My next YouTube with the next 6 will focus on conditional or springing power of attorney, co-agents, and whether you want to put a designation of what to do with your remains or who to deal with your remains in the power of attorney. So, and we'll contrast living will, and we'll talk about curatorships. So the next will be a little more advanced in this, but 6 more things that are kind of the exam answer is one thing, but the real life answer or practical tip is different. My final word is to say that it's my opinion, I may be wrong, but it's my opinion that you're not committing the practice of law if you tell people the practical effects of some of these decisions. So you're not advising them, you're not giving your opinion, you're not giving a legal consultation if you're a non-attorney notary. But don't shy away from. My advice is if you know what you're talking about and you're comfortable that your, let's say, description of the effect of a certain clause is correct, so you're not worried it's going to come back to haunt you as being bad advice. You're just worried that it's legal advice. I say quit worrying about that. If you want to tell them that, here's what happens with a conditional power of attorney versus here's what happens with a general power of attorney that isn't conditional, if you know what you're talking about and you're comfortable that you're giving them correct information, and I wouldn't couch it as legal advice or act like you're sounding like a lawyer. There's no reason to do that. You can just say, practically speaking, the difference is this versus that. You know things, and you should share those things with people and not really worry too much that somebody will say you're trying to practice law. They'll do that if you give legal opinions, and they'll do that if you file petitions with the court, and they'll do that if you try to sound too much like a lawyer, like you couch everything in terms of how experienced you are, even though you are. Uh, so as long as I think you phrase it properly. Okay, well, those were the 6 tips that I'm going to do today of differences between real life and the exam answer or the study guide answer. Again, nothing wrong with the exam answer, but your clients deserve maybe the Cadillac version of the power of attorney and not the bare minimum statutorily acceptable version of it. Thanks, guys.